Good idea.
We're about to get started with the second panel. I just wanted to let everyone know, if you are live tweeting the conference, please use the hashtag ISCOTUS. And if you're not live tweeting the conference, please start and use the hashtag ISCOTUS. So we begin our panel on ideology, neutrality, and self-deception with Professor Dan Kahan from Yale Law School.
Okay, I'm going to go really fast. Thank you very much for having me here. Now, this is a great conference, and I've already learned a lot from the first couple of sessions, so I don't just want to be a free rider. I'll try to add something. And I want to just start, of course, with this and ask you two questions. First, what is it? And second of all, is it male or female? And, because this is a well, it's a one-day-old chick probably, and that's the grasp that's being illustrated of the chick sexer, who's an important agent in the poultry industry, whose job is to segregate the male and female chicks at one day of birth. The female chicks are more valuable. The meat's tender, they lay the eggs, and the males kind of peck at them and hurt them, and so they kind of get exposed. I mean, they keep a few for a privileged existence, but it's really, and it's a sensitive matter, which is why they blacked out his eyes. And so, the chick sexer does this at this incredibly fast rate, hundreds an hour, and never makes a mistake. And this is kind of remarkable because there's no really discernible or at least articulable difference in the genitalia of the fuzzy little one-day-old chicks. Nobody can really say what it is, right? And so it's how do you figure this out? Right? How do these chick sexers perform this magic trick? And what happens, they go to like a school with the chick sexing grandmaster, and he shows them a slideshow. Female, male, female, male, female, male, female, male, female. And keep going and going for like days until finally they just kind of acquire the same capacity that the grandmaster chick sexer has to do this, right? And if you ask them, they just kind of tell you silly things like, oh, the nostril was flaring or something like that. Doesn't make any sense. And so, you know, and this is actually not, it's amusing, but, and it is worth trying to figure out, but it turns out it's not inexplicable, and it's not even singular. This is just one instance of a cognitive dynamic known as pattern recognition, which involves the conforming of phenomena that you take in by one or another sense to some stock, appropriate prototype in a stock of prototypes you have that are suited to performing some kind of mental task. And it's ubiquitous. Right? It's the way that people recognize faces and determine whether the emotions of people are anger or happiness and so forth and so on. It's the way that chess grandmasters actually figure out what to do, which is why they're able to beat the computer, just uses brute force. Until somebody programs the computer to do pattern recognition and beats the human, is what happened. It's also intrinsic to professional judgment in all kinds of contexts, right? So the emergency room doctors and nurses develops this kind of pattern recognition to determine whether the person who's coming in is having a heart attack, or even an accountant determines the signs that there might be fraud when investigating the records and so forth, right? So it's really a pretty ubiquitous thing, and it certainly figures in all kinds of professional judgments. And so what I'm going to do is make an argument here about the Supreme Court and the public that is going to rest on this dynamic of pattern recognition, which I'm going to use to connect three parallel connections here. One, between how scientists recognize valid science and how lawyers recognize what we can call neutral judicial decision-making, which is maybe valid judicial decision-making, if you like. Public conflict over valid science and public conflict over neutral judicial decision-making, what they're going to say is a problem with their pattern recognition relative to ours as lawyers. And then a parallel between how to communicate valid science, if you understand the role of pattern recognition in this, both expert and lay, and how to communicate neutral judicial decision-making. And those parallels actually are all kind of embedded in a parallel between these two books. One of them is by a late social ecologist, Howard Margolis, on the conflict between expert and lay perceptions of risk. And the other, of course, is Carl Llewellyn's account of how the common law judicial decision-making works. And these are both about pattern recognition. Howard Margolis links the conflict between the expert scientists and the public on all manner of risk, environmental, health, and so forth. Predated climate change, but nuclear was very involved, to a kind of incommensurability or conflict between the prototypes that are influencing the respective pattern recognition faculties of the experts and the lay public. So the risk experts, Margolis says, are people whose professional judgment is guided by pattern recognition, but they acquire prototypes through training and experience that allow them to identify the important qualities of the risks and how to mitigate them. Which isn't to say that they don't use data or reason, but the pattern recognition is what helps them to know what kind of data to accumulate and when it's been gathered in a valid way and what inferences to draw from it, and even to be guided by it normatively. And the discussions they have about their data, because it's not just recognition, is all about how to kind of help the others orient their patterns so that they see the same thing, and they will, because they have the same patterns, but they're distinctive and suited to their task. Members of the public don't have them, so if you just leave them to their own devices, right, they'll come up with all kinds of other different understandings of these risks. They'll wake up in the morning and see hotel guests face carbon monoxide risk. I saw it this morning. I was terrified. The expert wouldn't have even flinched, you know. So, but it isn't the case that the public's not guided by the experts. They know that the experts know something they don't, right? The way that they figure out what the scientists know is not by being able to see what the scientists see, because they can't. They don't have the prototypes. They have these mediating prototypes, both the scientists and the public, that enable the public to recognize who knows what about what. And science communication is about not giving the information the scientist used to figure it out to the person. It would be meaningless. But giving the person the kinds of cues and information that will enable this usually very reliable faculty of recognition of who knows what about what to work, right? And this usually works just fine, right? Except when it doesn't, because sometimes there are these gaps or holes in the mediating prototypes that are used by the public to determine who knows what about what. And at that point, the things the experts see will just seem weird to the public and the disputes about. I mean, that was Margolis' argument. It was kind of conjectural, but based on a lot of good synthetic material. I'll just give you a little bit of evidence for it involving the cultural cognition of risk. This is an empirical theory to try to explain variance and perceptions of risk. And the idea is that you can characterize people's basic general moral outlooks along these two dimensions: individualism, communitarianism, hierarchy, egalitarianism, and then assign people to groups based on the combinations of these outlooks. Right? And it turns out that people who share these outlooks have very similar perceptions of environmental, technological, health risks, and so forth. You can think of these as kind of the locations in which people are acquiring their prototypes and exercising their capacity to recognize who knows what about what, because these are the people they understand and so forth, and who have credibility with them. And usually, even though these are diverse groups in which these pattern recognition faculties are being exercised, people are converging. There's not a tremendous amount of agreement about what is known to science, and if one of these groups was consistently misleading its members on that, they'd probably be dead. Right? So usually no problem. But if there is a problem, right, if the groups start to come up with different answers, then you have the conflict. And there's all manner of conflict. It seems to conform to these patterns, like the risk, climate change and nuclear power risks, disputes over gun control, public health risks, social deviance risks and so forth. To give you one quick example involving the HPV vaccine, right? You know, the HPV vaccine, expert consensus that the girls 12 years old should be vaccinated for the HPV vaccine, which is this tremendously common sexually transmitted disease that is the only cause really of cervical cancer. Tremendous political controversy, right? So we investigate this, and we find that, well, people who have different values are in conflict a little bit. Give them some information, valid information about it, and they become even more polarized. Well, that's because they're using their lay prototypes, and here their lay prototypes in the different groups they're conjuring up different situations about what's going on, and they're polarizing. But you know what? They all listen to experts. They are going to do what the experts tell them, right? And the only problem then is if the experts they seem to be relying on are disagreeing, because who they recognize as an expert is going to be responsive to the kinds of prototypes they have of who knows what about what, right? And if the person that they think is like them is telling them what they're predisposed to believe, and the weird guy is telling them what they disagree with, you know, you get even more polarization. But you can flip that around, you know, if the person they trust is now telling the thing they otherwise would have projected, because after all, they go with the experts and so forth. And if this is the way it works, you end up with polarization only if the two groups, kind of certifying experts, are themselves, right, disagreeing about this sort of thing. And they're not disagreeing about pasteurized milk, you know. That doesn't happen, but it happens with the HPV vaccine. And same thing with scientific consensus. There is scientific consensus, but these guys with these values don't recognize that because these issues are very polarized. So you ask people, well, is this an expert on global warming, nuclear power, gun control? They have these elite credentials and so forth. And normally people would say people with those credentials are experts. We listen to them. But on these issues, right, if you do an experiment and you attribute to the experts opposing views on these things, right, people will say he's an expert or not an expert, depending on whether the view you attribute to him is the one that is dominant in their group. And so they end up divided. They both think, everybody thinks that the scientific experts should tell us what to do, but they're culturally divided on what scientific consensus is. You know, their normally reliable capacity to recognize who knows what about what is getting screwed up here, right? All right. Now, in law, right? Carl Llewellyn's legal realism is about pattern recognition. And normally we don't think of it that way because we all know that he's famous for having identified the indeterminacy of the law. At which point people say, well, then it's all what we had for breakfast or politics. You know, that wasn't the argument for Llewellyn. Llewellyn had a project. It was to describe how, notwithstanding the obvious kind of loosening and indeterminacy of the legal materials, there was nevertheless tremendous convergence and consensus and predictability among lawyers and judges on what the law was. And he attributed this to something he called situation sense, which was a perceptive faculty that was conditioned through professionalization. It endows lawyers and judges, he says, with situation types, these fact patterns, that they know what the appropriate result should be in. And legal argument for him is not irrelevant. It's the way you move the judge's understanding onto the right situation type, right? And so for Llewellyn, the situation types and situation sense are the equivalent pieces to Margolis's prototypes and pattern recognition, right? And although Llewellyn is really obsessed with consensus, I want to extend this and say, well, this can be the source of public conflict about the neutrality of the law, because the public doesn't have situation sense of the lawyer, right? They have their own prototypes that apply to these situations. They end up thinking the law is valid not only because of mediating prototypes that allow them to recognize that, oh, you know, that's a judicial authority appropriately exercised. And that usually works, but sometimes it doesn't, right? So in a study we did with a videotape of a political protest, we said, well, you know, watch this video and tell us whether the protesters were intimidating people or just engaged in speech. And in fact, it was a video of a member of the Westboro Church, the hate group that goes around and protests at funerals of the soldiers saying they're being killed in retaliation for toleration of homosexuality and so forth. And Supreme Court actually said that's by the First Amendment. Now we kind of concealed the identity and they didn't know Westboro Church members. But we told half our subjects that this was a protest at an abortion clinic, and the other half that it's a protest at a recruitment center against don't ask, don't tell. Right? And we have hypotheses about how people with these different combinations of values are going to see things. Right? And they see things very differently. Right? They think they're watching the same video, people with different values disagree. They think they're watching a different kind of protest, and people with the same values are disagreeing about whether somebody blocked somebody or screamed in the face and so forth and so on. Right? Or another example with the Scott v. Harris video. Remember, this one is where the police rammed the car, deadly force, to end the chase. And Scalia said, that's the scariest thing I've seen since the French Connection. And Stephen said, that looks like driving to work to me. We showed it to 1,500 people, various characteristics, and then formed models that allowed us to predict how people with different kinds of characteristics would see things. And this guy, who's part of the, these guys are that's part of the 47%. And this guy, he voted for Romney several times, and he saw this, but these guys didn't, and so forth. Now, this is a model maybe of how mock jurors do things, but it's more a model of how people are going to react when the court makes a decision. They're going to get little snippets of information, maybe see a video, hear something about it. They're going to be filled with strong views about what's happening because they have these prototypes in their head, the same way students do, so that when they read a case, they're filled with ideas about what really happened. And they're conflictual ones. Now, these cases aren't even hard for the Supreme Court. Came out 8-1, she has First Amendment right. 8-1 in Scott v. Harris. And lawyers weren't surprised. But you see, we weren't surprised because we know the kinds of materials that are involved here. And when we hear what the court says, it makes sense to us. We recognize that as neutral law. But they're doing neutral law and explaining it in ways that make sense to us, allow our situation sense to work. That's not sufficient to enable members of the public to see it that way any more than doing valid science is enough to enable members of the public to see valid science. There have to be these mediating kinds of prototypes. And if they're not there, and they often aren't, people are going to say, that's wrong. And when Scalia says, oh, no reasonable juror, I mean, he's saying what I'm seeing, he doesn't see it. And there's going to be this sense that there's something really wrong with the court in the same way that there's something really wrong with those scientists. Why? Because of a kind of communication failure. It's not intractable in science. We know that people end up in conflict about science not because they have some deficit in comprehension, right? Or some people don't like scientists. It's because there's this breakdown in the usually intact mediating kinds of prototypes. So the way then to fix it is through communication techniques that restore them or create them. And we've done experiments that show you can erase the polarization on issues like HPV or climate change and other things. Well, now if you see that there's this parallel between that sort of public conflict over science and this kind of public conflict over law, again, that suggests maybe you can do something. Some people say, oh, there's public conflict because the law is indeterminate and the judges are ideological. I think that's extravagant. We see conflict over science. That doesn't mean science is indeterminate or science is ideological. Another hypothesis is this one, that we have these defective mediating prototypes, and we have to fix them the same way that we investigate how to fix them with science communication. I don't have time, but I would tell you how to fix them. Actually, the next people on the panel will tell you things that are in the spirit of the kind of research I was showing you with science communication that try to identify what you would have to do to communicate the neutrality of the law, besides just do law neutrally and explain it in a way a lawyer would understand, since people who are in the public to whom you're trying to communicate aren't lawyers. Right? And that's it, although one last point about how to study public conflict over science and how to study public conflict over neutrality. The same way, which is scientifically, right? Gather evidence, have hypotheses, right? But then test them. Don't just hold forth and try to bully people into submission. That's not how it works, right? I mean, I guess that is how it works in a certain conception, you know, of how scholarship. That's not my prototype. I don't recognize. Mine is the one that has the pattern of conjecture, right, informed by thoughtful understandings of what could be happening, refutation and testing in the sense of empirics, right? Not storytelling and bombast. I won't name any names, right? This might not be, you know, this might not be right, might be possible, particular hypotheses might be wrong, but the thing to do is to try to investigate and test, right? And use a science of science, communication, and law the same way we do in other areas. So professional judgment at stake, right? So 12 minutes exactly, right?
Yeah. So our next paper is by Dan Simon from USC and his co-author Nick Scurich from UC-Irvine.
All right, so this is a joint paper with Nick Scurich, and we'll actually be, he'll present the second half of it. So it's really two papers, and you'll see that. Just want to start off by thanking Dan, and it's not me, it's Dan Kahan, who's a good reason for bringing us to Chicago. And I'm commenting mostly on just the first slide, is just kudos on the forward piece, because it bolsters the role of psychology in the legal discourse. It breaks the group of these purely theoretical accounts of adjudication. It calls attention to constituent elements of adjudication, much more facts and principles, and to the nitty-gritty rather than just the big grand theories. It highlights the intangible aspects of adjudication: respect, legitimacy, acrimony, distrust, things that Tom Tyler has been instrumental. And it emphasizes the problematic style of judicial reasoning, and I will paraphrase it as excessive reasoning. Dan uses, I think, the unequivocalness, the extreme unequivocalness, whatever it is, but it's the same thing. And that's what our first half is going to be about, is about that. And the reason this is dear to me is because I spent 2 years holed up in an apartment as a graduate student trying to figure this thing out, and I was talking on my SJD in an article that followed, one of those old anachronistic 142-page articles. I'm very attached to this because that got me into trying to understand the cognitive underpinnings of this phenomenon, which ultimately got me into the lab of Keith Holyoke, who's a cognitive psychologist at UCLA, and he kind of made me an experimental psychologist. So, just to get the point across, I'm going to just describe a case, a run-of-the-mill case, a boring, technical case, and not the kind that we usually like talking about. There's no abortion in it, there's no death penalty. It's just, by Dan's metaphor, it's pasteurized milk. Nobody argues about that one. But these cases come up, and courts have to deal with them, and sometimes they get to the Supreme Court, as they did in this particular case. And so let me just describe how the case looks like if you actually just read through it and try to figure out, you know, the moving parts in it. So this particular guy by the name of Valdemar Ratzlaff had a bad night in some Reno casino and owed them over $100,000. He brought a suitcase full of cash to pay them, and they said, actually, we can't take that much amount of cash. But they gave him a little, and they sent him from bank to bank not to surpass the reporting requirement that banks have to make for cash transactions of $10,000. So he did lots of 9,990 cash transactions. And the question was, did he willfully structure this transaction to evade the reporting requirement, which is a criminal charge? And so what does willfulness mean? And that's really what the case is about. Is it normal knowledge, or is it some heightened mens rea requirement? And if it's heightened, then it wasn't proved in court, then he was. The conviction would be reversed. If it's just normal mens rea requirement of knowledge, that was proved by the facts, therefore he should be guilty. So, there were 6 issues involved in this case as it came out in the court opinion. What is the textual interpretation of willfulness? What is the legislative history? Was the structuring considered nefarious? Because there's some doctrines for that. Does the rule of lenity apply? Does the rule of ignorance of the law is no excuse apply? And would acquitting him make the sort of the statute not make it sort of useless because you'll never be able to prosecute anybody. So this is kind of run-of-the-mill stuff we do all the time. So how does the court really go about reasoning this? So this is one sliver of the opinion, and it all deals with the first issue, which has to do with the textual interpretation. There it is. And don't bother reading the text. It's here not because I want you to read it. In fact, I suggest you don't. But things like, should willful be interpreted contextually? A term appearing in the same text must be read the same way. Provisions in the same subchapter require special knowledge. Statutory terms should not be interpreted to be service. The kind of stuff we do all the time, right? And each one of these is supported here. This proposition is supported by 3 cases, 3 precedents. This one's by 2, this one's by 5. So kind of a good legal argumentation, right? And then the question is, so out of all of these arguments and sources and inferences, how does it come out? And what's convenient about it is that they all line up to support the proposition that special knowledge is required, therefore he should be acquitted. And that's kind of cool. All right. So, what happens with the legislative history argument? There are tons and tons more. Don't read these. But believe me, they're all there, and there are inferences, and how do they come out? They also support the same conclusion. And if you look at the nefariousness issue, they bring lots of other examples from IRS, from taxation, from property and couples, splitting, structuring, blah, blah, blah. Everything comes out the same way, as does the rule of lenity. The rule of lenity applies, it's a big rule. But the rule of ignorance is no defense doesn't apply. You can make exceptions to the rule. And the administrability argument. So everything comes out beautifully. And if you count all of the inferences made here, there are about 64 of them, and they all converge on 17 lines of argumentation that all lead to the Holy Grail, which is acquittal. So this is powerful stuff, and it would make you think that legal questions have a single right answer, because how can you argue with all of that? And therefore, judicial opinion should be certain, really. Okay, judicial reasoning follows established methods of inference. It's always from the sources, through the rule of inference, to the conclusions. Judges are strongly constrained by the legal materials. I mean, look at all of that. Judicial honesty, of course, is implied. But what's missing is the dissent. And here's the dissent. And here you've got 61 arguments converting in 16 different lines of inference, and they all go exactly the opposite way. So what is going on? What do these legal materials mean? And I can do this on any case you bring, okay? Maybe not on 9 zeros because they don't bother, but any seriously argued case. And again, it doesn't require any politics, it doesn't require Dan's concepts of different cultural orientations. There are issues, as Dan notes, that just aren't that divisive. So, how one explains this craft, discursive practices, we've had opinions, maybe legitimacy and all the rest. That probably explains part. But I think there's a cognitive aspect going on here, and this is what triggered the experimental project. And the third has to do with persuasiveness. Judges might think that it makes it more persuasive, and that's what Nick will speak in a couple of minutes. I just want to hit on the second one. Maybe that's a cognitive phenomenon that we and judges share, that we impose a certain coherence on complex situations that happen to us in every day. I've got tickets to a dinner, to a theater, I was invited to dinner, there's a conflict. Lots of things are going on. Is the play going to be good? Is the parking available? But if I go to the dinner, who am I going to sit next to? Is the food going to be good? If I don't go to the dinner, am I insulting the host? And we can experience real severe conflict. At the end, we're going to do one or the other, and most of us are going to cope pretty well. So how do we get from that state of conflict to a state of what we call coherence, when everything kind of sits together fairly clearly, again, kind of where you have a pattern that you recognize and you're okay with. So this is, if you like, the underpinnings of the pattern. How do we make patterns when we look at situations like we do often in law, that there just doesn't seem to be any pattern because there are so many good arguments going every which way. So I don't have that too much time, but what I'd like to point out that these 6 issues that I mentioned before, they all feed into the decision, but at the same time, these are bidirectional arrows. Once the decision emerges, it radiates backwards and causes all of those things to fall into line and make the facts, the rules, and everything seem to support the conclusion. So I won't spend too much. So forget this. This is basically some of the experiments that I've been running over the years, and we've replicated them many times. In psychology, replication is good. It's not plagiarism. It's actually anything. As in other labs in the States, in Germany, in Sweden, it's become a bit of a cottage industry, but the same findings are there. And basically, if you take, I'll just give you the very short version. If you take certain judgments and inferences and you give it to people in the form of vignettes, okay, they'll judge one thing or the other. And then if you take those same judgments and you put them into a case where everything has to fit, and you ask them to decide a case and to make all those judgments again, you get very different judgments from the same people within the time span of about 10 minutes in the lab. I mean, 10 minutes that separate those two judgments. So if this is a pro-defendant attributes, the reds and the blues are pro-plaintiff attributes of it in case. At baseline, when they're just looking at vignettes, everything comes out kind of the same here. But once they've made a decision, everything splits apart into two coherent subsets. So in this case, it's this is people who happen to decide for the plaintiff. The pro-plaintiff attributes suddenly become strong, and they agree with, oh, obviously this is the case, whereas the arguments for the other side get dumped. And you get the exact opposite, the colors flip because we switched, and this is the consistent finding. So basically we just get to the, back to the legal reasoning. The certainty of judicial opinions and their judges' reports of constraints are probably genuine. It's a true cognitive state. But it's an artifact of the decision-making process. Judicial reasoning follows established methods of inference from facts, rules, and sources towards conclusions, but it also goes in the opposite direction. From emerging conclusions towards selective interpretations of facts, rules, and such. So that's the sort of the psychological underlying explanation, and now we're going to explore with more recent research the possibility that judges do it because they believe that their opinions are more persuasive to their audiences, and we'll be looking at lay audiences as opposed to professionals for the moment. This is the data.
So I'm going to run through 3 studies, perhaps unreasonably fast, but nevertheless kind of the essence. So as Dan mentioned, he was talking about primarily how judges make decisions. This line of research sort of looks at this from the opposite view. So kind of from the outside looking in, how do people react to their decisions and their style of argumentation? So we have essentially 3 studies that get at different aspects of this. The first one, which we published in the Journal of Empirical Legal Studies, looks at how people react to the decisions themselves and the type of reasoning that they offer to support their decision. And the second study looks at what effect, if any, general interest mediaries, so news reporters or even blog writers, I suppose, have on moderating how the lay public perceives judicial decisions. And then finally, and this is our most recent study, how are people influenced by the political affiliation of the judge? And with the caveat that how are they influenced by the political affiliation of the judge in non-politically charged cases, right? So it might be pretty easy to find an effect if the case is highly politicized or ideological in nature, but we're kind of asking the more conservative question, which is, what if there are no political undertones? Are people still influenced by political ideology? So the 3 studies follow the same general method. I'll just go through this quite rapidly. Participants who are members of the lay public were presented with cases that involve factual and legal issues. Each side in the case presented 3 different arguments. Participants were ultimately given a decision that was rendered by a judge. And importantly, we portrayed the decision-making process as about as good as it could get. right? So we told them that it followed the appropriate legal procedure, competent lawyers on both sides argued the case, and that the judge actually spent a considerable amount of effort in making her decision. So after reading these materials, participants were given several questions that got at sort of the quality or the acceptability or the legitimacy of the decision itself. So they were asked to rate their agreement along several dimensions. So how thoughtful was the decision? How rigorous was the decision? How legitimate is the decision? And we asked similar questions about the judge herself. So how competent is the judge? How much do you trust the judge? And so forth. And then we combine the results of all these measures into one composite score, which we can call legitimacy, although the name itself is actually unimportant. Okay? And finally, we asked participants, what would your preferred outcome have been? Okay? So the first case involved a legal issue, second case involved a factual determination, and the third case also involved a technical legal issue. Okay, so first study, what effect does the mode of reasoning have on people's reactions to the decision itself? So participants were given a judicial decision, and that decision was accompanied by one of four possible modes of reasoning. So first, no reasons at all. So they were just told the judge found for the plaintiff or the defendant. Okay? Another group was told, well, the judge found for the plaintiff or defendant, and here's one reason why. Okay? Another group was told, well, the judge found for the plaintiff or the defendant, and they were given numerous reasons for why the judge found that way. Okay? And this tends to be the prototype of most appellate court decisions where there's a bunch of reasons and they're all pointing towards one outcome, and there's never any acknowledgement that the other side even had a remotely plausible case. And then finally, the other group was given the decision and reasoning that acknowledged the complexity and the underdeterminacy of the case itself. So it said, we found for the plaintiff, for example, but really there were strong arguments on both sides. Okay, but ultimately we believe that the plaintiff or the defendant or whoever should prevail. Okay, so these are internet users recruited through an online company called Qualtrics. Let's get to the results. So what we find is that when participants agree with the outcome of the case, that is, they would have decided the case in the same way, the modes of reasoning that accompany that decision don't matter at all. Okay? There's no difference whatsoever in how acceptable or how legitimate the judge and the reasoning and the decision is. However, when participants disagreed with the outcome of the case, you'll notice first that they deemed the decision and the judge to be a lot less legitimate, but then they were differentially sensitive to the different types of reasoning. And you'll notice the purple bar all the way on the right, which represents the two-sided reasoning. So acknowledging that there was some complexity to this decision is viewed more favorably than the green bar right here, which is just kind of beating you over the head. This is my decision and this is why it's right. And interestingly, you'll notice that providing no reasoning at all was actually deemed more acceptable or more legitimate than just giving one single curt reason that supports your decision. Okay? So there's this huge contingency on whether or not the person agrees with the outcome and how favorable that outcome is. Okay? So in study 2, we wanted to examine the possibility that maybe this effect is attenuated when news reporters report on the decision. And maybe more along the lines of ecological validity, no one actually reads Supreme Court or appellate court decisions. They hear about it in the newspaper or on a blog, right? So what effect, if any, does that have? Does it possibly attenuate this sort of outcome-driven evaluation? So we took this up in the second study. It was exactly the same as the first study, except this time they didn't hear the decision from the judge. Okay, they heard it from a commentator. Okay, so the commentator's opinion is sort of like what you'd read in a synopsis or a newspaper article. Gave a summary of the facts and the legal issues, the arguments that were made by both sides, what the judge decided in the case, and then the commentator either agreed with it or disagrees with it. Just throw something at me. I'm really out of time for you guys. Okay? So just get to the results. Same thing, they answered questions about the acceptability and legitimacy of both the commentator and the judge. Okay? And again, you find this strong effect that when people agree with the decision, the judge is more acceptable, the decision is more acceptable. When they disagree with the decision, the judge is less acceptable, and so on and so forth. Okay? This plot illustrates what effect the intermediary or the reporter adds to it. So you'll notice on the left here, these are people who agreed with the outcome, right? And the blue bar represents whether or not the commentator agreed with the outcome. The red bar represents whether or not the commentator disagreed with the outcome, right? So in this bar, the judge said, I find for the plaintiff. The people also thought the plaintiff should have prevailed, but the commentator said, well, you know, the defendant really should have prevailed. And you'll notice that didn't substantially change people's evaluations of the judge, right? And a similar effect is found for when people disagree. Okay? It doesn't matter when people disagree with what the judge held. It doesn't matter whether or not the reporter agrees or disagrees with it either. Okay? Same finding for the evaluation of the expert herself. Okay, so it's the same thing. If you agree with what the expert says the correct outcome should have been, then the expert's great. She's, very thoughtful, very legitimate, very rigorous. And when you disagree with what she says, the opposite's true. Okay. Let me just get to study 3 real quickly. What effect does the political affiliation of the judge have in non-politicized cases? So, same methodology, except this time the judges were identified as being affiliated with Democrats or Republicans, or they weren't identified at all politically. Okay? This is the political affiliation of the participants, so it's about a third, nice even split along ideological lines. And what you find is when the judges are either Democrat or they're affiliated with the Democratic Party, or they're unspecified, it doesn't really affect how participants evaluate them or their agreement with the decision, right? So even Republican participants, they weren't statistically less inclined to agree with the verdict that the Democratic judge rendered, or the unspecified judge. Okay? But something funny happens when you tell participants it's a Republican judge. Okay? Then all of a sudden, Republicans are much more likely to agree with the outcome, and Democrats, perhaps not surprisingly, are more likely to disagree with the outcome. Okay? And I know I'm out of time, so just want to show that essentially the same thing happens with the evaluations of the judge and the decision that's rendered by her. Okay? Although it's somewhat attenuated. And I'm over, so I'll just end there.
Democrat or Republican? Our third speaker is Kahan from Yale Law School.
Perfect. All right, well, I'll thank Dan Kahan first for being the one that I think has provoked a lot of this recent way of thinking and discussing issues about the Supreme Court. And what I'm going to try to do is to build on his comments about potential distinction between the approach that I would advocate and the approach that he's been advocating in terms of what our concerns are. Why do we really care about when we're talking about the public in relationship to an institution like the court. There's a long history of talking about the ability of the court to do attitude change, to make a decision that affects people's attitudes or values. And Dan has stepped back, both Dans actually have stepped back into psychology and pointed to the mechanisms through which people defend their attitudes, defend their values, so that if they get some information that's inconsistent with their values, they're able to basically find ways not to change in response to that information. What I would argue is that that's a difficult problem, changing attitudes, changing values, but we actually, as legal authorities, don't necessarily need to focus on that. And if we focus on the question of deference, we see a more optimistic view about the relationship between the court and the public. Deference, acceptance, flows out of legitimacy, the sense of obligation and responsibility to defer. And it's not a decision about rightness or wrongness. When, for example, the study that Dan flashed on his screen that I did with Greg Mitchell on abortion, people accepted the right of the Supreme Court to make the abortion decision. They didn't therefore decide that their views about the morality of abortion should change. They saw themselves as responsible for following a legitimate institution. So the second point is that if we think of this as an issue of legitimacy, then what we want to do is we want to focus our attention away from the outcome, which provokes people to ask the question whether they do or don't accept the outcome, do or don't think it's right, towards the process or procedure through which the outcome is achieved. This is not anything that's new, either with my work or any other recent work. There's a long history in political psychology and political science of talking about the procedural basis of diffuse system support, procedural basis of legitimacy. But I particularly want to point to something that Keith mentioned already, which is the idea that we can direct people's attention to things that everyone can have in a Supreme Court decision, whether they get an outcome that they do or don't want, such as recognitions of their status, respect for their concerns, something we call relational reasons or status-based reasons for deferring. Okay. Let's think about three different ideas about why the court might be viewed as making its decisions. One is the traditional principle concept that's consistent with the law. But then if we ask, why do people distrust authorities, we see two different issues in the critique and then a response. One is that authorities are beholden to special interests. This is particularly a comment about Congress, but it's basically saying that elites, or at least not the public, is what authorities care about. So a response to that is to trust that citizen concerns are being given adequate attention in decision making. The other critique is that justices or other decision makers are ideological. Well, what does it mean to be ideological? It means that you're making decisions based upon your own values and not the values of the people or the public. So two critiques that can be responded to in the way that decisions are made. So what I'm going to talk about is a study that's like Dan Simon's study. It's based upon members of the public recruited online. I won't go into a lot of details because we don't have a lot of time and because there'll be a paper that you can look at. But basically, it's a very sample. What we did in the study is we asked people to identify a variety of moral or economic issues that did or didn't matter to them. And then we set up experimental variations where we could feed back decisions based upon issues to the public, knowing that they would either think that was an important or a not important issue. And then we gave them decisions by either Congress or the Supreme Court that either supported or opposed their position. So this is a fairly strong procedure in the sense that we want to see if you can do something in the way you make a decision that affects people beyond telling them that that decision did or didn't support their position. And of course, the argument that you've been hearing already is that we have a concern that people won't respond to procedural elements in a way that would go beyond a rejection of an expert or a decision or whatever that produces an outcome that's opposed to what they want, particularly if it's an issue that they have already told us it's important to them, say abortion or gay marriage or something of that type. All right. So we looked at a variety of different factors. I won't go into the details except to say that this is two institutions, the Supreme Court or Congress, and I'll separate those later, and experimental variations in the conditions of the different decisions. And my key concern, as I've said, is not whether people's attitudes are changed, but whether they accept the responsibility to defer to the court or to Congress. And I would argue that we're particularly interested in deference in the sense of acknowledging the right of an institution to make decisions. Because, as Justice Posner said last night, one question is who cares what the public thinks? And I think that one of the ways we care about the public is that the public determines the acceptability of having different decisions made by Congress, by the Supreme Court, by the President. They have opinions about who ought to have authority. And so that's a kind of deference, accepting that I accept this decision and also the right of the institution to make it. Now this is a regression equation of the type we've been seeing. I think the key point is to compare column 1 to column 2. If we only consider the outcome, obviously, people are more willing to accept decisions that are consistent with their preferred policy positions. But what's important is if we also add in the different procedural judgments that people are making, we see that beyond the influence of outcome, people are affected by all three of the procedural elements that I've already talked about. And in particular, although the fact that you might think that authorities are following the law or not matters, what's really striking is that the two more relational elements matter. In particular, it matters whether you think that the needs and concerns of the public are being considered adequately by the decision makers. So in other words, they're not overly affected by what we often pejoratively call special interests. They're actually affected by the concerns of the public. And also that they're consistent with the ethical values of the public, so they're not just a response to the ideology of the decision makers. I would say that, first off, this is very encouraging. And of course, it's consistent with other research that we won't talk about today, in saying that authorities do have an ability to make decisions that people feel a responsibility to accept across a range of ethical and economic decision issues that are important to them. And so there is an ability of these institutions to actually institutionalize their decisions among the public. And that's an important statement. It doesn't mean that their attitudes are changing, that their values are changing, but their acceptance of those decisions means they are accepting the right of these authorities to make decisions. All right. If we think about two different questions, is the decision an appropriate one and will you accept it? We see both are affected by these ideas of I trust that the public's concerns are considered. I believe that public values are being treated respectfully by the institution. They're being thought about. They're affecting the decision, even net of whether the decision is one that's favorable or unfavorable to your own values. All right. Further, if we consider whether it's a moral or an economic issue, a moral issue would be like abortion, and it's an issue that you have already described as important to you, then still we see this particularly strong influence of trust that your concerns are being considered essentially throughout as the central factor that's important here. The idea that you feel that adequate attention or consideration is being given to public concerns.
Right.
In this particular case, what I think is the crucial point is that people especially care about these procedural concerns when it's an important moral issue to them, like the kinds of issues that we're hearing about in Dan's work. The other issue is who's making the decision. The Supreme Court is on the left, Congress is on the right, and then we framed the discussion about procedures either by priming people to think about the justice of procedures or the injustice of procedures. We're talking about the Supreme Court today, and it actually doesn't make any difference for the Supreme Court in contrast to Congress, which we know has less legitimacy. People are always focused primarily on whether they feel that adequate attention is being given to public concerns and to thinking of decision makers.
Right.
So the Supreme Court has that ability more than Congress. All right. So if we focus on deference, we get a much more encouraging picture about the ability of legal authority to have a role in shaping important moral controversies. It's about acceptance based upon a sense that the court is using fair procedures, and that gives the court an ability to actually exercise its authority. But the other part of this is trying to have an expanded conception of what the court needs to do in order to tap into the public perceptions that I'm showing you are important. We need to have a sense in the public that the court considers their arguments, considers their point of view, their needs, knows about and thinks about and respects their values. That, I think, suggests that we need to have a broader conception of what we mean by procedures. It was interesting to hear the discussion about neutrality this morning, and neutrality is very consistent with ruling by principles of law. But to me, transparency is not the same thing as a response to the kinds of concerns that I'm showing you here. Transparency is openness, but as we've been hearing throughout the discussion today, the real issue is about whether the decisions made by political authorities communicate information to the public that allows the public to draw the inference that their concerns are being considered, that their values are being respected in the decisions that the court is making. And to me, that's what's really crucial, and it points very much in the direction of something that Dan Kahan talked about in his Harvard Law Review paper, and that Dan Simon and Nicholas were talking about today. And that is trying to make it clear to the people who are thinking about these decisions that there was a consideration of all of the public and the public's views, that there was an attention to the public's values. We don't usually see the Supreme Court writing decisions where those kinds of issues are given very much attention, are made very prominent. So in a way, you could say there's good news in this research and there's also bad news. There's good news in that there's clearly a way that institutions can build a strong public sense that they are using fair procedures when they make decisions. That's completely different than making decisions that are consistent with public values. On the other hand, the suggestion is that the way the court often functions doesn't really address these concerns, and so the court is probably not picking up these sources of public acceptance for its decisions, nor in fact is Congress. What needs to happen? I think that's a really interesting question. I thought the discussion, the panel on different blogs and posts and so on is really interesting, because we can report a lot of information about how the court is functioning, but it's really the court that has to act in a way that causes people to think that they care about public opinion. And having a lot of accessible information about the facts and the decisions and the reasons isn't addressing those concerns. Really, what would best address those concerns is if the justices would write opinions in ways that communicate their concern for public values, for public needs, something that both dams have advocated and certainly something that's supported by this research. Thank you.
Our final speaker for the panel is Carolyn Shapiro, a professor here at Chicago.
So thanks to everybody who's already spoken. And I'm going to talk about this idea of neutrality or objectivity in confirmation hearings, which is a very different context than what we've talked about so far. It may be on people's minds because now that the election is over, there is some reason to think that in the next 4 years, President Obama may get to appoint another Supreme Court justice. Of course, some of us, Linda Greenhouse and Judge Posner and I were talking last night about the possibility that, in fact, he won't get that opportunity, but we'll have to wait and see. But I actually started thinking about this question of how neutrality is discussed in confirmation hearings when Chief Justice Roberts had his confirmation hearing. I'm sure you all remembered his characterization of what a justice is, which is, right, the neutral umpire. Now, this umpire is actually, my 12-year-old would insist that this umpire is not calling balls and strikes. He's actually determining that somebody is safe at base, which is a different and perhaps more objective determination, but Chief Justice Roberts talked about calling balls and strikes as if it was a completely neutral enterprise. And of course, the problem is that if you don't agree with what the umpire has said, or you're rooting for the team that he's calling against, you might think that in fact, right, not only is he not neutral, but he's biased in the wrong direction. And I think that's really sort of the insight from Dan Kahan and Dan Kahan's work, in particular his Harvard Law Review piece and the work of Dan Simon and Tom Tyler, that it matters whether people think that that their considerations are being taken into account, and that if somebody is claiming to be entirely neutral and objective, reaching their conclusions through pure deductive reasoning, but then they reach a conclusion that you completely disagree with, that has implications for the acceptability, the legitimacy of that decision ultimately. So I got interested in this question of how the nominees talk about their job or their would-be job when they are in their confirmation hearings. And I want to say that Americans actually do pay some attention to these hearings, although, as Judge Posner pointed out, most Americans can't name Supreme Court justices. I think more Americans can name the Three Stooges than can name 3 Supreme Court justices. They actually, there is evidence that they follow confirmation hearings with some degree of attention. In a book about the Alito hearings, for example, Gibson and Caldera say they found that more than half of Americans followed those confirmation hearings either somewhat or very closely. So people are paying some attention. So I decided to look at what actually is happening in these confirmation hearings, and I'm doing this from a variety of perspectives, and what I'm going to talk about now is really just one piece of a larger project. But I'll just give you a little bit of background about confirmation hearings. They're actually relatively new, and certainly relatively new for nominees to routinely testify, only since 1955. There have been 28 nominees who've testified since 1955, but 2 have testified twice, Fortas and Rehnquist, who were both associate justices and then nominated to be Chief Justice. So there have been 30 separate hearings between 1955 through 2010 that I looked at. 25 of those 30 nominations were successful, This is just a list of the unsuccessful nominations, only one of whom is really currently famous, right, Judge Bork. 20 of the nominations were by Republican presidents and 10 by Democratic presidents. And all but 5 of the nominees were evaluated by a democratically controlled Senate. And one of the interesting things about this period from 1955 to 2010 is that there's not been a Democratic nominee who's had to be confirmed by a Republican Senate. We just don't, that hasn't happened in that period of time. We have had Republican nominees who had to be confirmed by democratically controlled Senates. So I also just wanted to point out how much attention senators appear to think people are paying to these hearings. This just shows the number of senators at each hearing who ask questions. In the beginning, sometimes nobody really asked questions. Justice Thornberry's hearing is 2 pages of transcript, if you could believe it. So some of them are just sort of little social, oh, it's so nice to see you, discussions, and obviously that's not what we see today. And here, this actually is kind of consistent with Judge Posner's idea of equilibrium. At some point, it became obvious this is the percentage of committee members asking questions. At some point in the 80s, it started to be odd not to ask questions. So now, routinely, 100% of senators ask questions in confirmation hearings. So what I'm going to talk about here is actually not what the senators say, but what the nominees say. I had a coding project. I had law students who coded confirmation hearings, and I asked them to identify whether the nominee asserts neutrality and objectivity at any given point during their testimony, and then also whether they admit that there's some room for judgment or subjectivity as either inevitable or good parts of judging. Then when I analyzed the data as I'm going to present it to you, instead of looking at each time somebody said one of these things, I just looked at pairs of nominees and senators. So there are 332 pairs of nominees and senators in the data. The independent variables I tried to look at, so I was trying to get at who says what, when. One is the perceived ideology of the nominee at the time of the nomination, which is a Siegel cover score for those of you who use these political science resources. And I also used the party of the president, which is an easier one to understand, and there really isn't much difference. I looked at the party of the senator that the nominee is talking to, whether the senator is an opposing party to the president, that is like, right, as a sort of, would the senator be likely, what might the nominee think about what the senator is worried about in talking to that senator. And then years since Brown was decided, it actually really means how long has it been since, from the beginning of these hearings till now, because these hearings became routine after Brown. And this is, of course, highly, highly correlated with the number of rounds of questioning, not just the number of senators who ask, but the number of turns they take at asking these questions. So here are some of the things that I found. A nominee is a lot more likely to assert claims of neutrality, objectivity, and by neutrality here, I think I'm using the term a little differently from the way Dan was using it. I mean, right, entirely objective, deductive, right? All I have to do is look hard at the legal materials and the answer will emerge. There's no judgment involved. So those kinds of claims are more likely to happen the more recent the hearing. When the senator that the nominee is speaking to is a Republican. And when the senator is a member of the party in opposition to the president, which, right, both of these make some sense. Right, if the senator is a member of the party in opposition to the president, then the nominee might want to assure the senator, yes, I'm going to be neutral, I'm not going to be, right, I'm an activist. I also have some coding on activism, and as far as I can tell, nobody's ever used that word in a good way, right? That's absolutely never a good thing. When the nominee has also acknowledged room for judgment or subjectivity in colloquy with the same senator. So there's some reason to think, right, if the nominee says, yes, there's some room for judgment, he or she may, this is a big inference, right, may also want to say, yes, but I'm going to be very neutral in my in the work in reaching those conclusions. On the other hand, admissions that subjectivity or judgment, ideology, you can use all kinds of different words. Nobody, of course, ever says ideology is part of judging, but they might admit that there's some room for judgment. Justice Kagan did that in her testimony. Is a lot more likely when the nominee is Democratic appointee or is more liberal as measured by these scores, and that's especially true before 2000. I mean, the post-2000 data set, of course, is 4, so it's 4 nominees. But you may remember that not only did Chief Justice Robert make these claims of neutrality, but so did Justice Sotomayor rather aggressively in her hearings. So there's been some shift in the more recent hearings. Before 2000, these claims of judgment, that judgment and subjectivity can play a positive or inevitable role, became more common over time. And sort of this is the flip side of if the nominee has made claims of judgment, they're more likely to make claims of neutrality. It works the other way around too. Sort of that's sort of necessarily so. So what are the implications of this? And here I'm going to just say, try to draw a little bit on some of the things that people have said already today. I think it's actually really problematic that what we see are nominees of us, Democratic nominees being more likely to admit that there's some room for judgment, while Republican nominees are more likely to say there's absolute neutrality here, absolute objectivity. And I think this might actually, and one of the reasons why I think that's problematic, I think, is related to the slides that the study that Nick and Dan shared with us that show that Republicans and Democrats actually have different reactions to what a Republican judges do. If Republican judges are claiming absolute neutrality, then Republicans, right, people who agree with them in their sort of cultural milieu or who see them as being consistent with their values are likely to say, of course, they're neutral, while Democrats are more likely to say, well, they're not taking my concerns into account. So I'm going to be less comfortable admitting the legitimacy. I think this actually raises an interesting question about whether it's better for the court's legitimacy or worse for the court's legitimacy to have one party, one set of nominees more likely to assert neutrality and objectivity than another, or whether it would actually, if we have to say, if nominees have to say that they're neutral and objective, some of my other work, I'm going to argue that they don't have to say that. Maybe it would be better. Would it be better if all nominees of both parties made similar assertions? Those are some of the types of questions that I'm going to be exploring in work related to this, including what are the types of questions that the senators themselves ask? How do the senators talk about the role of objectivity or subjectivity in Supreme Court judging? And what might they do differently in the future to bring a more realistic and, to use Dan's word, aporetic discussion of Supreme Court judging, admitting uncertainty. So, thank you.
So, we'll take questions now.
Can I encourage the panel to come up?
You guys want to come back to the front?
Can we ask each other questions?
You gotta move back there.
You want to start?
I have a question just by Carolyn's presentation. I think it applies to all of them. There has been a historical change in the court. In the early part of the 20th century, the unanimity was much higher than it is now. The court almost flipped exactly the rate at which they issue separate opinions. This is a dynamic that's quite different on the court. And so it occurred to me, Carolyn's case, I've learned as that changed, that was picked up in your data, it helps explain maybe why nominees feel free or unfree to say that they're doing something other than being purely objective. The competitive pressures on the court might produce excessive reasoning as you have more split opinions, particularly if you have Scalia, the center, can be very important to make your opinion political. There's a dynamic on the court itself, right, to reach a particular kind of reason. There are multiple splits, which presumably are more available to be read by everyone's schema. So I mean, this again occurred to me in the last 30 seconds. So the level of thought I've given it is not equivalent to the panel, but I wonder the degree to which this dynamic, or the court has moved away from what we call the normal consensus towards a norm of individualism, which is demonstrably the case in terms of the number of separate opinions we see, may or may not affect some of the dynamics that members of the panel investigated in their second work.
I think, I don't know if I can say something about the relationship between what's happening on the court and whether that creates the situation where nominees are more likely to claim this kind of objectivity. But I think it has potentially really damaging effects on the court's legitimacy in that, right, the nominee sits there and says, I'm a neutral umpire, I'm just going to do this deductive, objective reasoning, and then they get on the court and you open the newspaper and the newspaper says, well, the 5 conservatives voted this way and the 4 liberals voted that way. And of course, everybody can see that. It's not, you know, you don't have to read it in the newspaper to see that's what's going on. So there's this real mismatch between what the claims are at the hearing and what happens at the court. And perhaps if the norm of unanimity were still in place, which I'm not necessarily advocating, that mismatch would be less of a concern.
The one point with overstatement is actually almost more likely to be seen in the 9-0 opinions because the Supreme Court's main criterion for selecting cases is a division of lower court authority. And so they're all agreeing and they say, oh, all the points come out this way. But if that were so clear, why was there a conflict to begin with? The 9-0 opinions oftentimes are the ones where it's least credible that everything is so obvious. Now, does that have a cost? You know, I think we've been focusing, I mean, it's natural to look at like really high profile cases like the abortion cases and so forth. But I think that the possibility that the court is going to inflict a kind of unnecessary sense of disappointment and kind of insult on a losing party but losing constituency is almost, well, it's high in all kinds of cases, including the 9-0 ones. People. It's true most people don't pay attention all of the time, and maybe even, you know, most people don't pay attention any of the time. But in almost any case that makes it to the Supreme Court, somebody is paying pretty close attention. So like I think of the even the like the animal sacrifice, the animal cruelty case. That case, I think was it 8-1? I don't, you know, but now. It's not getting coverage in the newspaper, but it is the case that a lot of people are paying attention to that. And so they're vulnerable if it is the case that overstatement kind of undermines their perception that their side of things was really being heard. Right? So I think that I don't think that any of the cases are really, you know, immune to this sort of thing.
Can I just follow up on that? Sorry. I find it highly paradoxical and even worse than what Dan is saying, because the 9-0 cases bother me less than any other 5-4 when there's a dissent. So in that political case that I mentioned, when there's discussions about the legislative history, both sides say we don't have to look to legislative history when the text is unambiguous. And both sides say that the text is unambiguous on their side. So you've got 4 Supreme Court justices saying exactly the opposite, and you won't even admit ambiguity. So the logic is just, so I'm dumbfounded. I've never figured this out. I did this work 20 years ago, or 15 years ago, and I still don't know why we all buy into it. So to my mind, judges and car dealers have the same discursive practices than the rest of the world, and for some reason we just don't call them on it.
Yeah, that's true. It's practical. Well, if you say you raise this issue of whether it's psychological or kind of a craft norm, and I think that like in these 9-0 opinions, a lot of times they don't care how it comes out. It could just as easily come out the other way. They're just going to decide it. It's very work person-like. And they will say that, and if you ask them, we know it was more complicated, or it could have come out the other way. I think we would have to really test judges to see whether it's the kind of over-justification effect. I think most judges will say, of course, we knew it was hard, but when we wrote it, we were lawyers, and that we sold it. And it's kind of funny to think about the neutral umpire, because the closer the case, the closer the call, the more they sell it. And I think it's more, so I actually think that it's a craft form, you know, and what you just described too is that it's a car salesmanship, you know.
I'm Richard Sobel, I'm a political scientist. I do constitutional law, but also public opinion. But first a comment, the cartoon about the umpires, the biased umpires, Atlanta lost that game. So,
That's not to mention this.
I'm quizzing what that's sort of, you're biased towards the winning team and still they lose. So that's just a point. I have two questions. First question was the case about the $100,000 that the logic says both directions. How did that case come out, and how did it apply to the various approaches to it? And the second question is, would it be better if the court's public affairs office did a better job of explaining cases to the public? I'd be interested in how lawyers who argue before the court think about that, and how attorneys, the panelists mentioned, would the judges in fact allow their opinions to be presented in a way that might communicate better to the public? So how did the $100,000?
So, you know, I'll tell you, but the point is that it's not important because the conviction was overturned because 5 justices bought the 64 set of arguments and
he wants some legal advice. He wants to know whether he can structure his. So
you can go and structure deals with impunity, but
it was overruled by Congress. Yeah. Actually, yeah.
So, but my point is that, and the reason why it's not important, and again, one of these paradoxes. So you ask judges, well, why do you give the reason? Well, it's to, you know, direct future behavior of defendants and lawyers and courts and to help clarify the law. You're not clarifying the law. You're just almost arbitrarily picking when you're going to choose a rule or its exception. There's no rationale. There were 2 rules here, each of which has an exception, the rule of lenity and the rule of ignorance is no defense. And we use the rule sometimes and we use the exception the other time, and this is the more critical Llewellyn, right, Dan? And there's no rhyme or reason why it actually works out like this. Likewise, all those lots of other rules of interpretations, these middle-level kind of strategies, how you get from here to there, none of them actually mean anything because they're all going to be picked out, all their opposites in future cases. So what you're doing really is obfuscating the law. You're giving lawyers arguments to say, oh, but in Ratzlaff, the court decided this rule and not that rule. But that's nothing because in Smith decided 6 months before, it's the exact opposite. So the point is, you're just messing with the public. You're actually, to my mind, you're worsening the clarity and persuasive power and ability of players to actually understand what the law should be in future cases.
You know, I would respond to your second question by referring to the kind of the paradox that Carolyn notes, that justices clearly feel they have to present themselves in terms of neutrality and acting in a neutral and factual way. But I think that the point of a lot of the research is that the public isn't only or even primarily concerned about that. They're concerned about what are the motivations or the reasons that the justices are using to make their decisions, and in particular, the issues that Dan has mentioned. Are they paying attention to, caring about, thinking about the concerns of the public, the values of the public? So it isn't enough to just explain decisions and provide information. I think that there needs to be an expansion of the way we think about what kind of information would be relevant to the public.
I mean, there's a tension, right? If our approach to what the judges are doing is so deeply realist, but nonetheless, as your work shows, they really care about the process and seeing the right kind of process. is the showing them the process just as problematic as doing this other thing, if it's all just coming from some realist motivation to appear neutral, as Carolyn tells us?
This is a misunderstanding of realism, because it's true that those canons don't dispositively resolve things because they have exceptions and they're open textured, but most of the time lawyers and judges are converging on how they should be applied in particular cases. If you look at the Supreme Court, you got a really biased sample. The ones that necessarily got up there because people couldn't agree on them. But if you look at, I mean, most cases don't even get to court because lawyers have some sense of how the grand total of all of these indeterminate materials nevertheless will come out. And that's what Llewellyn was explaining, that those things create this kind of field within which the pictures of right outcomes actually become pretty visible. So I don't think it would be right to tell lawyers and judges, stop using your tools. But what it would be right is to tell them, don't think that just because you're using your tools correctly, people will know that you're doing it correctly any more than they'll know scientists are doing it correctly because they're doing correct science. You need communication tools that are suited for that.
So I'm happy to see that Dan Kahan is following the mold of Llewellyn from moving as he matures and ages from a critic to an apologist of the system. I am happy to discuss what the criteria that the court uses for deciding whether rules such as the rule of lenity or ignorance of the law actually are applied disparately.
But don't do the Supreme Court. It's a horrible sample. Right?
Oh, okay. Well,
I think we have to stop. Thanks, our panelists. Well done.